Christina Curls of the Appellate Defender Office for Mr. Alonzo. I request 3 minutes for rebuttal, please.
3 minutes is granted.
There's only one issue in this case, and that's whether or not the district court can resentence a defendant after his legal sentence has expired. This was originally a Senate Bill 123 case, and Mr. Alonzo was originally sentenced before the Court of Appeals decision in Holt came down, pointing out that the probationary period for a severity level 4 drug offense is 12 months. And the drug treatment can be up to 18 months, but that doesn't change the probationary period.
First question.
Yes.
Is the length of probation something that makes a sentence illegal? We have some cases out there that say probation really isn't part of the sentence.
I would say that yes, it is something that makes the sentence illegal because it, like everything else, has to conform to statutory requirements.
I understand that, and we have all the over the Senate Bill 323 cases back in 2000 where we reduced the amount of probation. All of those cases that say there's no authority to impose longer than statutorily set forth without making the findings. But does that render it illegal, if an illegal sentence, if we say probation's not part of the sentence? Do you understand what I'm asking you?
I do understand what you're asking. I would still make the argument that yes, a improper probationary period does affect the legality of the sentence. Because if, as in this case, the defendant goes through that probationary period, the legal probationary period, with no violations, and then 6 months after that legal probationary period ends, the state decides to file a motion to revoke. I mean, at that point, the defendant has done what was legally required by him by statute and what was legally required based upon what his sentence should have been. It may not be 100% clear, but his legal sentence on July 14th, 2005 was 12 months probation with the underlying 7 months. We are in no way challenging the underlying sentence. It's just that 18 months probation that was originally ordered without the judge making those findings. And because the judge didn't make those findings, the only legal probationary period in this case would have been the 12 months. So his probation ended. He fulfilled the terms of his probation on July 14th, 2006, when he didn't have any violations prior to that.
But if you can't get to the illegal sentence, then you're in trouble because he didn't appeal within 10 days of the imposition of the 18-month probation.
But he appealed within 10 days of when he was resentenced. I mean, the argument in this case is that the resentencing was not proper because it was without jurisdiction. It was without jurisdiction because his sentence in this case had expired. I mean, his sentence had expired, and there is case law, which I cited in my brief and the petition for review, that says once a defendant's probationary period, and they use the words probationary period expires, the court is without jurisdiction to modify or extend or change that sentence. Mr. Alonzo's legal probationary period expired on July 14, 2006. The district court didn't do anything with that probationary period until February 8th of 2007, when they revoked, reinstated, and extended for 18 months from that date. The first action the state took was about a month earlier when they filed the motion to revoke probation on January 12th of 2007, which was still 6 months after the legal probationary period expired. Since his legal probationary period had expired, the district court was without jurisdiction to revoke his probation on February 8th. They had no probation to act, and every action after that legal probationary period expired was without jurisdiction and therefore void.
Had he appealed from that first sentence and been in the same situation that Defendant Holt was in, and the court would have found error on appeal, and if the court had done what they did in Holt and remand and say, turn back the clock and resentence, and at that point, basically they said, even though that period had expired, he could be resentenced to the longer period. What's the basis for distinguishing that situation from this?
The basis for distinguishing that is at the time Mr. Holt filed the notice of appeal, his sentence hadn't expired. His sentence hadn't expired. He hadn't served the 12 months probation and then been revoked. I realized that in Holt, the state was arguing that it was moot because his probation had been revoked and he had actually served the total underlying sentence. But he was still allowed to go back, and the court was still allowed to go back and make those findings. But it's in a different procedural place than this case is.
Basically, the appeal froze.
Exactly.
Everything.
Exactly. He appealed the actual length of the sentence at that point. The basis of the appeal was the 18 months probation. The basis of this appeal is lack of jurisdiction. The lack of jurisdiction for the district court to have done anything on November 8, 2008 or October 23, 2008, when they went back and made those findings over 2 years after the legal probationary period had expired and over 2 years after jurisdiction had ended. That's the basis of our argument, is that jurisdiction ended on technically 30 days after July 14, 2006, since courts have held that a motion to revoke probation can be filed up to 30 days after after a probationary period expires. Because nothing was filed within those 30 days after July 14, 2006, the district court's jurisdiction to do anything with Mr. Alonzo's probation ended. Every action that they took after that, the revocation and reinstatement of probation, extending it another 18 months on February 8th, was void because there was no jurisdiction to do it. The resentencing on October 23rd, and then they resentenced again, the same findings, they just had another hearing, I believe to allow the parties to make additional arguments. Both of those actions were void because there was no jurisdiction in this case. The jurisdiction ended when his probationary term expired. That is Mr. Alonzo's argument in this case, is that once the probationary term expired and the state didn't take any action within 30 days of that legal probationary term expiring, jurisdiction for the district court to in any way modify his sentence expired, and every action thereafter was void. So we'd ask you to reverse the district court's decision to reverse the district court's decision to resentence and make those additional findings to extend his period of probation to 18 months and discharge Mr. Alonzo from any further liability on this case.
Do we have any questions of counsel?
My understanding of Holt is it relies on the statutory language that an illegal sentence can be corrected at any time, and it took the tack that if this was illegal because of a lack of findings, then the findings can be provided at any time. Why wouldn't that rationale apply here as well?
Because the challenge in Holt was made while the sentence was there was still jurisdiction to do something with the sentence.
But the statutory language doesn't seem to support that distinction. It says an illegal sentence can be corrected at any time. And if you're going to allow after-the-fact correction or a correction with after-the-fact findings, what difference does it make when it is?
It makes a difference because I mean, as the Court of Appeals has held, and as this court has held, that district court findings made without jurisdiction are void. Court of Appeals has held, and I haven't found any Supreme Court case that says the same thing, but the Court of Appeals has held that the district court is without jurisdiction to modify probation after the probationary term expires. You combine those two cases together, the idea that the district court has no jurisdiction to modify probation after that probationary term expires, and this court's holding that a judgment of the district court made without jurisdiction is void, then in this case, when the judgment of the district court was made over 2 years after jurisdiction expired, even if it was a motion correcting what was an illegal sentence under Hoyt, the judgment is still void because at that point, Mr. Alonzo had already served his sentence. He had already served his legal sentence.
I think the question is whether you can combine those two cases, though, in a situation where the defendant did not appeal the sentence, which has the legal effect of making that sentence binding. And as announced, that sentence did give the court jurisdiction. I mean, I don't know if you can collaterally change what was a final judgment unless you, and if you say it was illegal, which would be a different situation, does that mean you, I mean, under the reasoning of Holt, you could roll the clock back? I think what you have to be able to establish is that the court lost jurisdiction during that extended time period, and I don't know that you've made that link.
All as I can rely upon for that is, like I said, it's Court of Appeals case law. I haven't found a case from this court stating that jurisdiction ends when the probationary period expires.
When the legal probationary period expires is what you're saying.
Right, when the legal probationary period expires.
Because he still was on court-ordered probation.
Right, but the legal probationary period in this case was only the 12 months. That legal probationary period expired on July 14, 2006. Because nothing occurred prior to that, no motion to revoke was made within 30 days of that, jurisdiction to change that sentence ended. And because there was no jurisdiction, every decision made by the district court after that was void based upon this court's holdings. If there are no further questions, I would ask this court to reverse the decision of the district court.
Do you have any more questions? Thank you, counsel.
May it please the court, Jason Orpace on behalf of the state. Your Honors, before I proceed, I know when we were before the panel of the Court of Appeals, the question that they had for me basically was what's been happening to Mr. Alonzo since this case has been pending. We did send a letter that was dated June 7, 2012, indicating to the court that Mr. Alonzo has been released on this case. He was serving 2 sentences. One was this sentence. The other was a sentence out of Johnson County for which his probation was ultimately revoked for here. Judge, I think what the appellant seems to be missing is that when the court resentenced Mr. Alonzo, he was still under the 18-month court-ordered probation. When Holt came down, the court took that finding and essentially made the findings under 214611C5 to extend his probation to the 18 months. The court didn't originally do that. What they were doing, in essence, was correcting an illegal sentence.
Would this rule extend to apply to the period of incarceration? In other words, if the district court sentenced Mr. Alonzo to the hard 40 life sentence, and after 25 years, Mr. Alonzo would move to correct an illegal sentence because there had been no findings that were required, and so the hard 40 was imposed contrary to statute, that it just gets remanded to make the findings to support the hard 40?
I think that's what at least the panel of the Court of Appeals, that's at least how I read their opinion, was that when there is an illegal sentence, the remedy is not to go back to what the default sentence should have been, but what it said was you can correct whatever problem there was with the sentence that was imposed, make the required findings, and then, in fact, make the sentence legal.
And so if the criminal history was wrong or whatever, you can go back and you can establish something different and make different findings.
Well, I'm not sure if it's actually making imposing a different sentence. It would be correcting what the court should have done originally.
I understand.
Perhaps I didn't understand.
I understand a clerical correction, but this wasn't simply a clerical problem. It was a failure to make specific findings that are a condition precedent to the sentence imposed, and to allow the court to go back afterwards and say, "Oh well, I would have if I'd have known that I had to do it in order to support this sentence." Just doesn't seem to pass the due process test to me. Why is that not fundamentally unfair to go back and change the game and let the court make findings that it didn't make it the first time?
Well, I think that at least that's where the statute comes in that allows the court to correct an illegal sentence at any time. That if at least...
It wasn't an illegal sentence. The 12-month was a legal sentence. The court imposed a sentence that could have been legal if it was 12 months.
Okay. I guess I'm just not following your question.
Okay. Go ahead and make your argument.
Judge, there's really not much more I can say regarding the facts of this case. The court, by imposing an 18-month sentence as opposed to the 12 months that was at least allowed by statute, the court did impose an illegal sentence and then essentially followed the holding of Holt and made the factual findings that were required to extend the probation beyond the 18 months. I also would note that from the Court of Appeals opinion, there was never an appeal from the original sentence as it was imposed back, I believe it was in 2005. I believe it was when the original sentence was imposed. There was never an appeal from that decision, nor was there an appeal from the...
What was there to appeal of the original sentence?
Well,
wouldn't Mr. Alonzo agree that he had a 12-month probation? That's what was imposed.
Apparently,
what was there to appeal?
Apparently, pursuant to Holt, the original 18-month sentence that was imposed would have been illegal because the court failed to make the requisite findings to extend its probation beyond the statutory 12 months. There was never an appeal of that. At least from the way I've understood that Senate Bill 123 kind of came on, or at least was interpreted, was that there seemed to be a confusion between the 18 months that was allowed for the drug treatment versus the 18 months that was required, that courts were imposing for their probationary period. There's, I guess, an interpretation that by allowing a person to enter drug treatment for up to 18 months, that was what was setting the probationary period at 18 months. It wasn't until Holt came down that courts started to realize that to extend the probation beyond the 12 months, there needs to be factual findings to extend it that far, to 18 months.
Any further remarks, counsel?
No, Your Honor, I would just submit to the court that the decision of the district court was proper and would ask this court to uphold the Court of Appeals.
Could I clarify? I think I heard you say that the court did impose an illegal sentence in 2005 when it imposed the 18 months probation. That was an illegal sentence in your view.
Based on the opinion of Holt, that was an illegal sentence. That without making those requisite findings, I believe it's under 214611C5, that the person or either the welfare or the inmate or the public safety wouldn't be benefit from a shorter period of probation or the statutory 12 months, that they have to make those findings before you can impose the 18 months. By imposing the 18 months without making those findings, that makes the probation period illegal.
Any more questions of council? I see none. Thank you.
Thank you.
There are 3 minutes.
I just want to use this time to address Justice Johnson's question about whether or not the probationary period is part of, because I think when you were questioning the state, I finally understood what it was that you were asking. Personally, the way I read motion to correct illegal sentences and the case law on a motion to correct a legal sentence, if it doesn't conform with the statutory provisions, it's an illegal sentence. The way I've interpreted that and the way I've argued that is because the probationary period doesn't conform with the statutory provisions, that makes it illegal. However, if this court were to find that probation isn't a part of the sentence, that it's only the underlying sentence, then the district court, without question, didn't have jurisdiction on November 8th or October 26th to go back and correct the sentence. Because if the probationary period isn't a part of the sentence, which is, I think I've finally understood what it was that you were asking. If that probationary period wasn't a part of the sentence, then there's no other legal authority at all for the district court to have gone back to correct that sentence to make those findings. So I guess there are two alternative arguments here. One is that the probationary period expired 12 months after it was imposed. And after that point, there was no jurisdiction to modify it. After the probationary term expired, there was no jurisdiction for the district court to go back and modify it and extend it to the 18 months, or to even extend it 18 months on that first motion to revoke. Alternatively, if this court finds that the probationary period isn't a part of the sentence to begin with, then the district court had no jurisdiction on October 23rd or November 8th to go back and make those additional findings.
I think the real question here, seems to me, is whether the specific findings that are required by statute constitute a correction of the original sentence or a modification of the original sentence. You're characterizing those findings subsequently as being a modification of the original sentence. Opposing counsel's characterizing that as simply correcting what should have been done or what the court intended to do.
I would argue that they were, without question, a modification of that original sentence. The statutes haven't changed since Holt. The statutes are the same at Holt as they were in Alonzo. The district court, had they looked at the statute, they could have seen that the legal probationary period was 12 months. They could have seen that what Senate Bill 123 provides is that treatment can exceed, the drug treatment required by Senate Bill 123 can't exceed 18 months. They aren't conflicting. By going back on October 23rd and November 8th and making those findings, he modified the sentence. It wasn't a change in the law that he wasn't, or that he shouldn't have been aware of at the original time he sentenced. He just didn't know of it, or he didn't recognize it. He didn't realize it. So he didn't make those findings to legally extend the probationary period. So when he went back to do it on October 23rd and November 8th, that was a modification of his original sentence. If there are no further questions, I would ask this court. Yes.
I'm still having trouble getting my head around the fact that Mr. Alonzo didn't appeal the first sentence, didn't appeal from the Holt correcting sentence, if we can, or hearing, if we can call it that, and ends up with a benefiting from that, whereas all of the other Holt-related defendants that appealed got stuck with the 18-month sentences, basically.
Could you repeat that for me?
Yeah. Well, I mean, under your analysis, Mr. Holt ends up with a 12-month probationary period simply because he didn't appeal that sentence in the beginning, and he didn't appeal from the Holt-related correcting hearing that Judge Harth did.
He did appeal from that.
Well, from, up to that point.
Okay.
And so then the Holt-related defendants, we have a whole, I don't know how many, a large number that came through the system that appealed from those first sentences. And those defendants, by exercising their appellate rights, end up, I'm sure in many of those cases, with 18-month sentences because they were remanded for the court to make the findings. And so I'm still just having this disconnect as to how that happens.
I guess my argument would be is the remand to make the additional findings, even in those other cases, it is improper. It's improper because, as I just stated, it's a modification. It's not a correction. It's a modification because they're going back to make an additional findings to make a sentence that they made legal. When if they were actually going back to correct the illegal sentence, they would go back and they would order the 12-month probationary period. By going back and allowing them to make those additional findings to extend it to 18 months, it's not correcting an illegal sentence per se, it's modifying the original sentence because they're making findings that they, without question, could have made at the time the defendant was sentenced to begin with. I guess that's the difference, is I disagree with the
remedy provided in Holt. With the remedy, and I put that in quotes, provided in Holt.
Right. I disagree
making...
with that remedy, that it can be remanded to make the additional findings. And that's the best answer I have for your question as to the disconnect, that shouldn't be the remedy. If there are no further questions, I'd ask this court to reverse the decision of the district court.
Thank you, counsel. Court will take this matter under advisement. We thank both counsel for their arguments this morning. Now turn to the